Okay, so it looks like we're going to go ahead and get started. We have a couple of attendees with us at the moment and several others that are going to be trickling in, I'm sure. So yes, let's get started. Thank you for joining us today. This presentation this morning is about shedding light on the Corporate Transparency Act, which you have no doubt heard is quite a complicated piece of legislation to navigate, and we're hoping today to make things a little easier for you to determine who your beneficial owners are and determine whether you will need to make this filing with FinCEN.
Great, and I just want to let everybody know to please, at the end, we'll be having our Q&A, so submit your questions there. And if you have any technical issues, you can submit that to the chat. That'll go directly to me. Thank you.
Wonderful. Thanks, Melissa. And so a little bit about us. My name is Luna Hernandez. I have worked at Merhab Robinson and Clarkson for approximately 3 years now, initially as a paralegal in the corporate transactional department, and then most recently as an associate attorney. So I love this firm. I'm hoping that we have seen one another in passing or exchanged an email. So yes, looking very forward to assisting you today. So I'm going to go ahead and jump in and get started. What is the Corporate Transparency Act? So this act became effective in January of 2024, so earlier this year, and the government says that it's intended to aid law enforcement in combating illicit activity conducted through anonymous shell companies. What it does is it requires certain privately held entities to report beneficial ownership information to FinCEN, the US Treasury Department's financial crimes enforcement network. And what is sort of different about this law is normally you would see larger entities quite comfortable with reporting this sort of information, but this has really cast a broad net and is now requiring far smaller companies to go ahead and file very sensitive information with FinCEN. Today, we're going to touch on a few high-level items. Firstly, I will assist you in establishing whether you are indeed a reporting company using some general principles and determining whether you must submit the beneficial ownership information report. So wherever you see on the slides that it says BOI, that's what we're talking about, the report that you file with FinCEN. There are several exemptions to reporting, 27 to be exact. I'm not going to be going through every single exemption with you, but I will be touching on the 3 that we think might be most applicable to your particular types of businesses. We'll then look at what type of information needs to be reported, the timing requirements for filing both your initial report and then any changes to reports that must be filed. We're going to go over the very hefty penalties, both criminal and civil, that you will fall victim to if you do not comply with these reporting requirements. And then also assist with determining who the individuals in your company are who will be determined to be beneficial owners. And lastly, we'll give you some compliance tips on the steps you can take to comply, as well as some current constitutional challenges to this particular law. Right. So the very first step in this process, and the one that you have to meet before you even continue with your investigation, is you ask the question, am I a reporting company? And it's important to note that both domestic and foreign entities can be reporting companies under the CTA. So your domestic reporting company is any company that has filed a document with the Secretary of State. So for instance, if you were a corporation, you filed your articles of incorporation with the Secretary of State, an LLC, your articles of organization, you may have a limited partnership certificate. Any entity that you've gone and made that filing, immediately you fall under being a reporting company. The same applies to foreign entities. that have registered to do business in any state in the US or a tribal jurisdiction. So it is not enough that you are a foreign company and you think that you might be exempt. If you have registered to do business here, you are very likely required to file. Okay. This is a slide that gives a high level of all of the exemptions, or just a few of the exemptions, actually. I'll go very briefly over them, and then I just want to hone in on one or two of them. So you'll see public companies. These are companies that are very used to reporting their information to the government. They will not be required to. You see your public accounting firms, governmental entities, pooled investment vehicles. And then the two that I really want to ask you to look into for your own companies is this large operating company exemption. And I'll go into a little more detail about that. Firstly, you will need to have been in, you would need more than 20 full-time employees, and those are employees of that particular entity. You have a physical office in the US, and that's not shared with any other entities. You have reported more than $5 million in gross receipts or sales on your filed prior tax return, and that excludes gross receipts or sales from sources outside the US. So if you meet all three rungs of that test, you will likely be considered a large operating company, in which case you will not have to report. The second exemption that we see frequently is for an inactive entity. And the requirements for meeting this particular exemption is that the entity had to be in existence on or before January 1st of 2020. It's not engaged in any active business. It's not wholly or partially owned directly or indirectly by a non-US person. It's not experienced a change in ownership in the 12 months prior to reporting. It hasn't sent or received any funds in an amount greater than $1,000. So nothing more than $1,000 going through your bank account. And then does not otherwise hold any kind or type of assets. So you may think you have an active entity, but the minute it's holding a piece of property for say, it then would not be an inactive entity and it would be required to report. And this is just a continuation of the slide before. Also securities brokers, dealers, regulated public utilities. I do know that a lot of these exemptions will not apply to this particular group today, but just to be aware that if you fall under each of these, you may qualify for an exemption. Okay, so let's say you have now determined that you are indeed a reporting company and you must report. What information are you reporting? The reporting company is going to have to disclose information about its beneficial owners. And we'll go a little deeper into who is a beneficial owner in a couple of slides from now. And then for entities that have been created after the effective date, and the effective date was January 1st of 2024. So anything that was formed after that date, you're also going to have to give information on company applicants. So a company applicant is the individual who either directly filed the document with the Secretary of State or the person who was responsible for directing or controlling the filing of that document. So in the context of a law firm, if we had a client come to us after the effective date, so now and say I need to go ahead and file my articles of organization for an LLC, not only will it be the paralegal who directly files that document with the Secretary of State who will have to file her information with FinCEN, but it will also be, let's say myself, the attorney directing that filing. Both of us will be required to give our information. And then obviously the reporting company is also disclosing information about itself. So as to each individual beneficial owner and company applicant, you're going to have to give the full legal name, date of birth, their complete current address, I want to point out here, this is a residential address. This is not a company address. That's what the government wants, as well as a unique identifying number and then a copy of the image of that document. So you are actually submitting a color copy of, let's say, your passport to FinCEN. Something that would be helpful to people who have interests in various different companies is that you are actually able to go onto FinCEN's website and obtain a FinCEN identifier for yourself. And the benefit in doing so is that every time you have to make a filing for an individual company, instead of putting in all of your information again, you will simply be able to disclose your FinCEN identifier, and the filing will obviously go a lot quicker. In a couple of slides, you'll see, though, there are requirements for updating information, and it's important that if you went ahead and got this FinCEN identifier, that you're making sure you're keeping that information updated. So the reporting company, we've spoken about what the beneficial owners need to report about themselves. Now the reporting company must report the following: its full legal name, any trade names. It's important to note this is your FBN, whether it's formally registered or not, your complete current company address, the state of formation, and then also your EIN, your IRS taxpayer identification number. So the next slide is regarding the timing of these filings. So if your company was formed before January 1st of 2024, so before the effective date, you currently have up until December 31st, 2024, or midnight January 1st, 2025, in order to make this initial filing. If, however, you have a new company that was formed January 1st, 2024, you currently have 90 days in which to make that filing. And then after January 1st of 2025, that time shortens and you're actually only going to have 30 days to make that filing. I have mentioned before that it's not only the initial filing that you'll need to make. If any information changes on that filing, you only have 30 days in which to report. So that's a very quick turnaround, especially when you look in the context of gathering many beneficial owners information. It's going to become very important to put a system in place that triggers you to know when you need to go ahead and make this updated change filing. And these are just some examples that you can see of information that would need to be reported if it had changed. However, it really is any information. If you take your report, if anything on that report changes, you are going to need to file an updated report within 30 days. And this is the slide that gets everyone kind of up in arms, and rightfully so. There are both civil and criminal penalties for not complying with this particular law. There are mandatory penalties of $500 a day up to $10,000, and then there are permissive penalties of imprisonment for up to 2 years or both for any person who willfully, and I do want to hone in on that word, willfully, provides or attempts to provide false or fraudulent beneficial ownership information, or fails to report complete or updated beneficial ownership information to FinCEN. There may also be penalties to reporting companies and individuals who cause a reporting company not to report and are senior officers of a reporting company at the time of its failure to accurately report. So I have previously had questions about what happens if we have a shareholder who just refuses to give us the information. You know, they just won't. You are completely within your rights to tell them. Unfortunately, there may be penalties for that. You're causing a reporting company not to report, and that could be individual liability for you. So now we've discussed the reporting company, we've discussed who needs to report. Now we need to go into this investigation of who is a beneficial owner. So the definition under the law of a beneficial owner is any individual, and that word is important because they're looking for human people, not entities, who directly or indirectly either exercises substantial control over the reporting company or owns or controls 25% or more of the ownership interests of the reporting company. So if you own 24.5% of a reporting company, and that is your only connection to the reporting company, you aren't an officer, you aren't a director, only own 24%, and you don't control the company in another way, you will not be required to report as a beneficial owner. However, it's important to make sure that you're looking at both rungs of this test, substantial control and owns or controls 25% or more. We then look at what is substantial control. So although the Act doesn't actually go into great detail about what substantial control means, FinCEN has issued a small entity compliance guide, which I will certainly encourage you to go onto FinCEN's website and download. It's a very helpful document. And in this, they've provided guidance of who would rise to the level of exercising substantial control. First, we have anyone who serves as a senior officer of the reporting company. So this is your president, your CEO, your CFO, your COO. Note there that they have not said the secretary. So that's somewhere where you may not need to have someone provide their information. Additionally, any person who has authority to appoint or remove either any senior officer or a majority of the reporting company's board of directors or a similar body. Any person who directs, determines, or has substantial influence over important decisions made by the reporting company, and then has any other form of substantial control over the reporting company. So you'll see that they are really casting a broad net here. Anyone who can be seen to have substantial control is going to need to report. In a similar vein, so we've discussed substantial control. Now, a beneficial owner is someone who has a 25% or more ownership or control interest in the company. So again, very broad definition here. It can be an ownership interest of stock or equity, pre-organization certificates, subscriptions, and an interest in a joint venture. So all different forms of ownership. And the types of ownership go over onto the next page here. You'll see even if someone has an instrument that is convertible, so let's say a convertible note into stock at some point, they may need to file as a beneficial owner. So the purpose here of showing you all of these different types of ownership interests is to say that if you have some sort of non-traditional interest in a company, we highly advise you to seek legal counsel to determine whether that interest would constitute an ownership interest in the reporting company. Something that we see all the time is, or at least here all the time, is the question, well, I own my interest through a trust. Do I have to go ahead and report? So the answer is yes. The Small Entity Compliance Guide has issued some guidelines here about who under a trust would need to report their individual information. And so firstly, it's your trustee of the trust or two trustees of the trust, any other individual having authority to dispose of the trust assets, could be a beneficiary who either is the sole permissible recipient of the trust's income and principal, or has the right to demand a distribution or withdraw substantially all of the trust's assets. And then, although we frequently see in the trusts that we review that your trustees are often the grantor or the settlor, sometimes they're not. And if they aren't, and they have the right to revoke the trust or otherwise withdraw trust assets, they are likely to need to report under this law. So all this to say is if you hold your interest in a trust, here we would also advise you to seek legal counsel to review your trust and determine whether specifically any beneficiaries or the grantor or the settlor rise to that particular threshold. There are some exemptions to individuals that are required to report. And so, for instance, if your minor child is a beneficiary under a trust, they will not be required to file. Also, individuals acting as nominees, intermediaries, custodians, agents on another's behalf. So, for instance, your corporate agent, they're not going to have to go and report the information. Certain employees who are not senior officers. So right now, we are saying we don't see that a vice president is a senior officer, unless for some reason the control that they've been given or the influence they've been given rises to that level. And what this does is really requires an individual analysis into the structure of your organizational chart and honing in on who are these individuals who control this company, not only on paper, but in practice. Heirs are also exempt, and then certain creditors of the reporting company. So now that you've heard all of that, you're a reporting company, you've identified your beneficial owners, what's next? How do you comply with the CTA? So firstly, we ask you to determine the individuals who are your beneficial owners. And then you need to start the process of timely obtaining their required personal information. It seems like a far-off deadline, December 31st of 2024, but if you have to coordinate with several people who may not be always as forthcoming with giving their information, you will quickly see that this deadline is looming. So we really do encourage you to get a head start on gathering this information. And then putting into place within your own companies a system where you are notified and promptly notified, because you only have 30 days to make the filing, of any change in the beneficial owner's information. It's important to remember that an individual may indirectly own or control an ownership interest in a reporting company through ownership or control of one or more intermediary entities. So for instance, a reporting company with one or more entities as owners or in management, and this example is quite pertinent. For instance, you have a limited partnership with an LLC acting as a GP. You may need those entities to provide you with beneficial ownership information. This slide is largely touching on what I've just spoken about, is putting in place a system whereby you are promptly notified of changes in information. And it's also important to note that you may require some sort of analysis of your organizational documents, such as your bylaws or any other sort of shareholder agreements, to determine whether there are any people who are listed therein who have this control element to their role in your company. We are coming to the end of the presentation portion, and before we finish, I do want to let you know that there are already challenges to this law, and not surprisingly at all. March 1st of this year, there was a district court ruling that ruled that the CTA was unconstitutional, stating that Congress was overreaching. And the court actually ruled on that and said it was. However, their ruling would only apply to the plaintiffs in the case and then to members of the National Small Business Association. So I have had questions before, well, can I just become a member of the National Small Business Association and then I don't have to comply? And unfortunately, the answer to that is no, although that would have certainly boosted their membership. You had to have been a member at the time of the lawsuit, so and at the time that the ruling was handed down. However, if you are a member of the NSBA, I would encourage you to also seek legal counsel. Make sure that you're receiving an accurate determination that it does not apply to you from your own attorney, and that may be a way for you to not have to report at this time. So given that this ruling only applies to certain people, we proceed as if nothing has changed until told otherwise. This particular date is still in effect. And that is the end of the presentation, and just on time. We had planned just under 30 minutes for that. I am going to hand it over to Melissa, who hopefully has a couple of questions.
Hi, Luna. Yes. So we got a couple of questions in the chat, and I know that a few are still coming in. So feel free to go ahead and those of you in the audience, submit any questions you might have in the Q&A. And so I'll get started with our top question, which is this requirement for all employers, private and under 30 employees?
All employers, private and under 30 employees. So yes, all employers. The first thing that jumps to mind when I hear under 30 is the possibility of a large operating company exemption. This applies to entities that have more than 20 employees. However, you would also have to meet the next two rungs of the test, which is that you have a physical office in the US that is not shared with any other entity, and have reported more than $5 million in gross receipts or sales on the prior year's federal tax return, excluding gross receipts or sales from sources outside the US. So it's not enough to just be a 30 employee entity. You have to also meet the gross receipts or sales of 5 million, as well as the physical office presence.
Great, thank you, Luna. And on to our next question. Somebody wants to know, what if a trust is owned by an IRA?
I do not know the answer to that. I would say you should reach out to your attorneys and have them make an individual determination on that. What I will say, though, is that if we're just speaking about trusts in general, a trust itself does not need to report. It's not a reporting company. However, if your company has a trust that owns over 25% interest, and then the trust is owned by an IRA, I would definitely encourage you to seek direct legal counsel on that. I personally haven't had a situation like that before.
Thank you, Luna. We have one other question. Where can I get the criteria you just mentioned to find out if we need to report?
So you have several different options here. I would go onto FinCEN's website and download their small entity compliance guide. I'm going to actually also put my email address up over here. We also offer the service, obviously. We have built a system that can assist you with complying, and it takes you through these various steps. And it's a direct prompted system based on the legislation. So it's much more palatable than just looking at the entire law. But if you were to embark on doing this on your own, I would say your best place to go is FinCEN's website. And there are plenty of resources on there in order to help guide you.
We got a couple of questions in the chat as well. Somebody wanted to know if I already filed my statement of information with the Secretary of State, why must I also make this filing?
Gotcha. So this is a common question that we get, and it really is. I've already given the government my information. Why do I have to give it to them again? So the statement of information that you file, let's say in California, that is a state filing that you are making. So this particular law is a federal law, and it is the federal government that now needs your information. And not only that, it is far more expansive in what it asks for, this particular FinCEN report, because you can see you're having to upload information such as your passport. It's asking information about beneficial owners, whereas your California statement of information, it only requires you to disclose your directors, your officers, your corporate agent, and obviously your address, as well as a attestation as to any prior labor judgments against the company. So far more expansive federal government.
Great. One other one, if I plan on dissolving this year, do I still have to make this filing?
Right. So currently, we are advising clients that if they plan on, not only plan, but will execute the dissolution of their companies by the end of the year, they will likely not be required to file, simply because by the time that the deadline comes, they no longer have an entity in existence. So a point there that I would say, though, is make sure that if that is your plan, that you have in fact dissolved by the end of the year. There are no outstanding items. The paperwork's been filed. You've wound up. You've filed your final tax returns. Don't leave anything on the table that would create an appearance that you are still in operation.
Okay, great. And then someone wanted to know if the information that they report would be considered public.
So not public as in anyone can search a database. FinCEN has provided guidance saying they are going to have this in a closed system and just for their use, and they will only relay this information to governmental entities as required. Now, what that means, we don't know. We haven't seen it in practice yet, but they are saying at this point, it is meant to be private and just for governmental use. I can certainly see a world in which they're sharing this information with the IRS, given that your EIN number is being reported.
Great. I think that's all the questions we have.
Great.
Does Luna, do you do these filings for companies on their behalf?
We do. So
Yeah.
I think I touched on just now that we had built this particular tool, and you have my email address here. You're welcome to reach out and we can give you more information about that. I do note that a number of the attendees on today are already existing clients of ours. So if you have seen our e-blasts, you'll likely know that we are encouraging people to take this law very seriously. So please reach out to us if you need to, and we'd be happy to start you on the process of making this filing. And yeah, you have my telephone number, you have our mailing address. We'd be happy to answer any questions that you may have.
Okay, great. It looks like that's it for today. Thank you
Wonderful.
all so much for coming. Any final words of advice, Luna?
Comply with this law. Definitely take it seriously and seek legal counsel.
Yes, exactly.
Okay.
Great.
Thanks,
Well, you guys,
everyone.
thank you, everyone. Have a wonderful day. You know where to find us if you need help.
Thank you. Bye.
Bye.